This is Jus Cogens, the International Law Podcast from Leiden. My name is Omar Akif. On this show, we discuss the latest developments, concepts, and judgments from the world of international law with leading scholars and practitioners. Hello, and welcome to the second episode of the Jus Cogens International Law Podcast. Today's show is about extraordinary renditions and strategic human rights litigation. Joining us today is Dr. Helen Duffy, who is quite familiar with both of these matters. Dr. Duffy has practiced international law for over 20 years, engaging in high-level human rights litigation before regional and international human rights courts and bodies. She is a professor of international human rights and humanitarian law at Leiden University Law School here in the Netherlands, and she also runs human rights in practice that specializes in strategic human rights litigation and the rule of law. Through her work for human rights in practice, she provides representation in cases before regional and international courts and bodies. This brings us to the first matter of discussion today, which is extraordinary renditions, if you haven't guessed already. And we'll be talking specifically with regard to the recent European Court of Human Rights judgment on Lithuania's involvement in secret CIA detention program, leading to many human rights violations. Thank you so much, Professor Duffy, for taking out time and being on the podcast today. It's truly an honor.
Thank you, Omar. It's a pleasure to be here. Thanks very much.
All right, great. So let's get the conversation going. Before we can get into the judgment itself, it would be great if you can give a brief overview of the case itself.
Okay, so the case that I was involved in was the case of Abu Zubaydah against Lithuania. And Abu Zubaydah was the first of the high-value detainees, as they were called, to be taken into the extraordinary rendition programme. He was captured in Pakistan in 2002. And then he disappeared into black site secret detention for a number of years thereafter. One of the states on whose territory Abu Zubaydah was held in this secret detention was Lithuania. In fact, Lithuania was the last of the European black sites. So this case was a case that was brought against Lithuania for its role in his secret detention, torture, inhuman and degrading treatment, and various other violations of his rights. So the Abu Zubaydah against Lithuania judgment came down on the 31st of May of this year. And the judgment found that Lithuania was responsible for the violation of Abu Zubaydah's rights under the European Convention, partly through its failure to prevent and to protect, but also through its active collaboration and participation and facilitation or acquiescence and connivance with the CIA in his secret detention and ill treatment on Lithuanian soil. So the judgment found a violation of various rights under the convention. It also found that Lithuania was obliged to carry out a meaningful, thorough, effective investigation now and to hold criminally accountable those who are responsible for their role in this rendition programme.
So before we go into the details of the judgment, how do you see this decision broadly, and what does it mean for cases like Abu Zubaydah and the accountability of extraordinary renditions in general?
Yeah, I mean, I think the judgment is in and of itself of significant importance, but I think the true significance of the case really depends in large part on what happens with the judgment now, right? So it's important that the judgment is used, I think, by advocates and others in order to try to press for greater, more effective investigations, greater accountability, and to addressing the ongoing violations of Abu Zubaydah's rights today. Because the fact is, these are not historical violations, because his rights continue to be violated in Guantanamo today. Having said that, I think that even where we've got to thus far is significant in a number of different ways. Partly, I think will I wait till
That's fine.
That's a shame, yeah. It's always the way when you're recording, you automatically pull out the ambulance as soon as you press record.
Perfect timing.
So I think the judgment is significant in a number of different ways. One of them is that it pulls together all of the evidence that's available to date, at least not all of it, but much of the evidence, and there's a great deal of evidence that's available to date in relation to the nature of the programme. So I think it provides an important contribution to historical clarification in terms of the nature of this really horrendous, secret global torture programme. It also makes very clear the role of states like Lithuania, where up to now the state has continued to engage in simple denial of its involvement. I think the judgment helps to put beyond plausible deniability the role of Lithuania. And I think it's an invitation to Lithuania, but also to the many other states that participated in this programme. And of course, the number 57 is one number that's often cited of the number of states that contributed in one way or another to this programme. And I think the judgment is an invitation to those states, in a sense, to deal with their involvement, to grapple with the past and ask difficult questions about why this happened and make sure that we learn lessons from it and it doesn't happen again. And the fact is that to date, despite an enormous amount of information that's now available about the programme and the highest level responsibility for it across many, many states, the fact is there still haven't been adequate investigations, as the judgment makes clear, in relation to Lithuania. And there's been a real dearth of accountability. So impunity has to be addressed as a matter of priority.
Do you think as long as Abu Zubaydah is detained and other such prisoners, such judgments have little ground impact apart from maybe delegitimization of those programs and a symbolic negation of those programs? How effective is it in reality?
Yeah, it's a good question. I mean, in my academic work and in my written work, I certainly look at the question of strategic human rights litigation impacts and what makes this litigation significant. So I certainly agree with your question in the sense that I think we shouldn't assume the significance of judgments like this, and we should look at the reality on the ground in terms of what impact does it have on the people who brought these cases, but also on many other levels. And as I say, in a case like this where the judgment's just come down, we don't know the full impact yet. It would be premature to assess the impact of a case like this when the judgment has just come down. Because to a large extent it does depend whether or not this judgment is used as a tool to press and pressure and lobby and engage in bringing about levels of change that still need to happen. I think it does have a symbolic importance, and I don't think that should be underestimated. I mean, I think the role of the courts in the face of these kind of really egregious wrongs by governments around the world, the role of the courts in reasserting the law is incredibly important for the maintenance of the rule of law. So I think there's an expressive value in a judgment in that sense. But it's also a symbolic judgment for a human being. I mean, this judgment will not liberate Abu Zubaydah, right? That's a much longer challenge. But I think it does have symbolic importance for him in the sense that it is a recognition of him, and it's the first time that he's ever had judicial recognition in his cases against Poland and Lithuania at the European Court. It's the first time he's ever had judicial recognition of the fact that he was tortured and he is a victim. And, as the courts referred to, he continues today to be held in what the court calls a flagrant denial of justice. So it's recognition of the wrongs committed against him, of his humanity, of him as a rights bearer and a human being. And that's, you can call that symbolic importance, but that's real importance, I think, for a human being. He was awarded 100,000 euros of damages from both of those states, symbolically considerable sum from the European Court of Human Rights. So I think that's important. Of course, to get back and perhaps to reflect back your question, the true importance of it will depend on whether or not it's used as a tool for more effective investigation, accountability and learning lessons in the future, and whether or not it's used as a tool to try to really, once and for all, bring to an end the flagrant injustice that he's being subjected to today.
There's a lot that we don't know about these cases. Well, there's very limited sources of information that we get. especially if we talk about the high-value detainee program, which, as of now, it has come into public knowledge. Do you think there's a chance that the HVD, the high-value detainee program, will be repackaged and replaced by other similar measures, similar to, if you remember, the sanction lists, which I remember from your course, where they took them from one sanction list and put them into another. Is that possible? Is that likely to happen?
Yeah, but just to pick up on the first thing that you said about how much we don't know about these programs, I think that's a very important point, that there is still a lot of uncovering of the truth that needs to be done. And the European Court of Human Rights really emphasised the right to truth. That his right to truth, that the right to truth of society as a whole has to be respected, and that involves, a full uncovering of a fuller truth than we have at the moment. At the same time, I do think it's quite remarkable how much we do know about this programme. As the European Court said in its recent judgment, this was shrouded in secrecy. There was a veil of secrecy before, during and after this programme. But the fact is, the European Court's judgment was based on public source information, and there is, in fact, a mass of evidence that's now available publicly as to what happened in this programme, despite the fact that it was intended to be a programme that we would never know anything about.
Yeah.
So I feel that there's also a cause for some optimism in that it is simply impossible today, I think, to keep a global torture programme completely secret. So I think that's encouraging in terms of human rights monitoring. And the fact is, the evidence is overwhelming. The evidence of state responsibility, but also, frankly, of individual responsibility, which is why the impunity to date is so difficult to countenance, because there's no shortage of evidence. But to get to the second part of your question, I think that one of the lessons of this programme is certainly that we need to be vigilant. We need to remain vigilant, and there is, of course, the possibility that there is a repackaging of something like the extraordinary rendition programme. I mean, what we know is that this programme took many different forms, and there are many different ways in which states have engaged in torture, particularly in the counter-terrorism context in recent years. So this is an extreme example where the CIA ran a black site facilitated by other states, so ran a completely secret interrogation centres around the world. But we also know that sometimes individuals have been sent off to other states for what's been referred to as torture by proxy, where perhaps the state responsible for triggering this doesn't get its hands as dirty, but ultimately the results are the same. So of course we have to be vigilant against repackaging, and we have to learn lessons from this. We have to not just kind of put it in a file as a historical fact, but we have to say, what measures do we need to take in order to ensure non-repetition? What does that really mean? And I think that means accountability at lots of different levels: state, institutional, individual, corporate. There's so many different levels of accountability that are still outstanding.
I'm glad you still have some optimism regardless of whatever is happening. And you talked about proxies, and in light of these recent legal developments and this judgment in particular, do you think there's a chance that these renditions might shift from the Western world, from Europe, to although Abu Zubaydah had a whole world tour, as sad as that it may be, to limit accountability, to move these renditions to Asian countries or maybe non-European countries where there's even lesser accountability, and with for example, appointment or figures like Gina Haspel, who is now the head of the CIA. Do you think will these programs continue as they have been in the past? And if they will, would they move from the Western world to other countries where there's lesser accountability?
I mean, first of all, we have to remember that this was already a global programme, right? So we're shining a light through cases like this at the moment on the role of European states. But for example, if we take Abu Zubaydah, I mean, he was detained in Pakistan, of course. He was then transferred to Thailand. That was his first secret detention site. And we have copious details in terms of what happened to him in Thailand, in terms of his torture, in terms of the cables that were sent to his torturers before they engaged in torture, guaranteeing that they would have impunity and guaranteeing explicitly that he would remain incommunicado for the remainder of his life. So all of that happened in Thailand, detailed evidence as to the responsibility there of individuals and of the state. And then, of course, he was also transferred to various other places. As you say, he had a world tour in terms of, Morocco, Afghanistan, as well as the European sites. So all that's to say is that other states have, it's not been a European sponsorship, it was a global sponsorship. But of course, your question goes to accountability gaps. And that's something that we need to continue to work on. The fact is, you mentioned Asia, it's of course hugely problematic that there's no regional human rights mechanism for Asia. There's no equivalent of the European Court of Human Rights, and of course there should be. So the reality remains that for the majority of the world's citizens, we don't have the kind of regional and international remedies that Abu Zubaydah has been able to pursue against Lithuania. So possibly it's the case that where there is accountability, that makes the states where you can secure accountability, that makes them less attractive partners for unlawful cooperation in the future. I'm certainly okay with that. I think we just need to work on ensuring that there is that kind of accountability across the globe.
How do you see the role of information channels such as the U.S. Senate Committee report on torture by the CIA? And then there have been such reports and such committees have been very useful in bringing evidence to light. Do you think these would continue to be frontrunners of increasing transparency and accountability of unveiling aspects of such programs? Or do we have more such instances of bodies who are working towards this?
Yeah, it's a good question because I think one of the things that's fascinating about the rendition program is that, despite its intense secrecy at all levels, the reason we're able to know so much today, as reflected in the European Court's judgment, the reason it was able to come to that judgment and decide that it was beyond reasonable doubt that the state was responsible, was because of the meticulous investigation by a whole host of different sources of information. I think the Senate Intelligence Committee report from the United States was, first among equals in that respect. It had a hugely important contribution, obviously because they had unique access to internal CIA documentation that other inquiries haven't had. So that was a very important piece of the puzzle. They had 1,001 references to our client, so they provided us with an enormous amount of information as to his torture, as to these kind of guarantees that had been given, as to impunity for that and his incommunicado detention, etc. Also as to the lies and misinformation, by the way, about our client. It was clear from the Senate Intelligence Committee report that the assertions about our client having been a high-level member of Al-Qaeda were based on lies and misinformation that continued to be repeated time and time again. So an enormously important source of factual information that fed in a way that was greatly complementary to the European Court of Human Rights process. The Senate Committee was only one. We've seen other parliamentary inquiries, even in Lithuania, to give that parliament its due. There was a parliamentary inquiry that called for a criminal investigation. Regrettably, that criminal investigation that followed was never adequate. But that parliamentary inquiry also played a role in terms of clarifying that there had been some kind of agreement in Lithuania and this demanded to be addressed. And unfortunately, as yet, it hasn't been adequately addressed. Also on the regional level, the Council of Europe inquiry, the European Parliament, for example, and of course on the national level in many of the other states as well. We shouldn't forget the role of civil society.
Plane spotters.
The plane spotters,
Yeah.
You remember? We talked about this in the course, that's right. Really unlikely human rights defenders crawled out of the woodwork on this one. Individual plane spotters, but, civil society, committed investigative journalists who stayed with this story long after many others would have left it behind when they were being accused of bizarre conspiracy theories, but they stayed with the story. And together, all of those sources, I think, have fed into the position we're in today, where it is simply no longer possible to deny the facts. What now has to happen, I think, is the accountability, a thorough learning of lessons, as well as addressing Abu Zubaydah's situation.
Yeah. Also in the judgment, I read that the court asked Lithuania to make representations to the US to make amends and to accept their responsibility and their role in the rendition programs. How likely do you think that is going to happen? And what shape would that take?
Well, yeah, I thought this was a really interesting aspect of the judgment, actually. It was quite unusual that the European Court, in a judgment, in the section dealing with damages and reparation, would make clear that a responsible state was required to make those kind of representations to try to bring to an end the fruits, the results of its unlawful cooperation. So I thought that was significant normatively, if you like, and it's significant for future practice in relation to reparations. Poland, there was a case, as you know, against Poland in 2014, also on behalf of Abu Zubaydah. And Poland, although it wasn't in the judgment in that case, Poland did make representations to the United States, asking for clarification of Abu Zubaydah's current situation and asking for certain undertakings. Unfortunately, the United States didn't respond to that. So is it likely that Lithuania will make those representations? I assume so, because it's required in the judgment this time to do so. In and of itself, do I have any illusions that is going to sort the situation when Lithuania makes those representations? Well, obviously not. But I do think it's important symbolically that, not only Lithuania, but all of the other states that were involved in bringing about this situation now assume their responsibility for bringing it to an end. And that can be individual and collective measures.
Moving on to something else, do you think it's problematic that the court not only found substantive violations of, for example, Article 3 regarding to torture, but also procedural violations that Lithuania failed to investigate properly? These measures are undermining due process of international cooperation and also international cooperation due process everywhere. Do you think that rings alarm bells for the rest of Europe? That a European country, failed to investigate human rights violations on its territory as it should have ideally done so?
Yeah, I think it's hugely important that the court emphasised the obligation of Lithuania to respond, a continuing obligation. The court emphasised that it would be a continuing violation if Lithuania fails now to conduct the sort of investigation that it's required to conduct, to hold individuals to account, to provide a remedy and reparation, to satisfy the right to truth, for example. And it's only as the court made clear, I think, in the way that it presented those obligations and the failures of Lithuania in that respect, why these things matter. They matter because it's about securing confidence, public confidence in Lithuanian institutions, right? Confidence in the rule of law. So I think it's incredibly important that there are these investigations. It was very clear that the investigation that Lithuania said it had conducted just did not meet the benchmarks of a meaningful investigation, a thorough investigation that really probes the facts, that tries to get to the individuals responsible even at the highest levels of government. So the failures, I think, were clear. The benchmarks set down by the court for what constitutes a thorough and effective investigation are important for Lithuania in the future to meet those, but also for other states, because many other states have the same obligations. And sadly, Lithuania is not alone in having failed in those obligations to date.
Talking about international cooperation, there were requests for legal assistance to the US, which made no progress.
Yeah.
There was a deadlock, and it seemed inevitable because of the contrasting state interests of the US and interests of human rights bodies like the European Court of Human Rights, and the general framework of international human rights is not exactly compatible with state interests of the US as far as this is concerned.
Yeah, no, of course it's a matter of great regret that the United States refused to cooperate with a legal process in another country, right? I mean, a state that, for many years, of course, was at the forefront in international measures of accountability. So, of course, that's a matter of great regret. At the same time, other states can't hide behind the United States' failure to meet its human rights obligations and the United States' failure to cooperate to justify their own failure to carry out an effective investigation. United States cooperation is important for these investigations, but it's not absolutely essential. There's enough evidence available to take forward investigations, notwithstanding the impediment that involves.
Final few questions, just a couple of them.
I don't know if I answered your last question. I wasn't sure if I
understood. Perfect. Before we move on to the next part of the discussion, which is on your upcoming book, Strategic Human Rights Litigation, which is coming in September, I believe?
I believe so, August or September. Yeah,
okay. So I know you already talked about this, about the damages which the courts awarded, 100,000 in non-pecuniary damage and 30,000 for costs and expenses. Any thoughts on that?
Yeah, I think, the damages are important for symbolic reasons. The court made clear, it explicitly said that they were awarding 100,000 damages because of the extremely serious nature of the violations in the case. So I think that it would be important to say that this case was, not about money. That's obviously the case, right? That in terms of your goals in a case of this nature, damages are quite far down the list. It's not the reason you do the case, but I think it was appropriate that he was given a high award of damages. Of course, he was also given a high award of damages against Poland. At that time, he was on a UN sanctions list, and therefore the transfer of funds could not be made. But it's also interesting to note, in terms of strategic litigation and the various different developments that have been in his case, that Abu Zubaydah has now been delisted by the UN sanctions list on the basis that he was not a member of Al-Qaeda. It's an Al-Qaeda sanctions list, which I think says something quite important also about his current situation. He continues to be detained. Originally, his detention was justified on the basis that he was a number 3 in Al-Qaeda, and the UN ombudsperson has said that he was not a member of Al-Qaeda. The US government no longer even contends that he was a member of Al-Qaeda, but he continues in detention without any due process of law. So the damages award is important, but it's certainly not the most important thing.
Final question on Abu Zubaydah case. Well, just responding to your previous answer, I think it's not easy to let go of your favorite guinea pig if you are using all of your interrogation techniques on that person. But that's good news that he's been delisted from the list of Al-Qaeda. Last question, this is a bit long. Given that the case is largely based on circumstantial evidence, only the US legal representative had access to Abu Zubaydah, only one person. And that combined with declassified US Senate reports, also international inquiries by the Council of Europe and the Parliamentary Assembly, also the British NGO, Reprieve Bureau of Investigative Journalism, which led to more information coming out. How important are these external means of extracting information? And how can we open more doors for such inquiries and international investigations where these third-party actors are contributing?
Yeah, so it's true that there were because he continues to be held in incommunicado detention in Guantanamo, there was very limited access to him. I don't have access to him. More importantly, as the judgment makes clear, he didn't have access to the court in any sense, right? So we couldn't present to the court an affidavit from the applicant, right? So that, as you suggest, is not only an impediment or a challenge that you have to overcome in doing this kind of litigation, but it was one that could be overcome because of the investigation of all of these different sources and entities that you've referred to. I think I've already said that I think the role of all of these entities that you've referred to and others is crucially important, because we simply wouldn't have the information. We wouldn't be able to base a case on public source information were it not for the meticulous investigation and the tenacity and the willingness to engage in the long haul of all of those organisations and investigations. So it's incredibly important. I think it really speaks to the level, I think it speaks to how far you can get and how many challenges you can overcome when you do have, complementary roles of different entities, and you do have collaboration between lawyers and NGOs and journalists and international and regional and national level inquiries pulling in a similar direction. And then, of course, the role of the courts, which is separate but incredibly important in terms of authoritatively ruling on those facts and finding, as they did in this case, that it was inconceivable, was the court's word, right? It was inconceivable that states did not know, and yet they offered full participation for this torture program.
Thank you. I think it's better to move on to a